Let me start by also welcoming my two stalwarts with me on this panel, Mr. Sapan Gupta as well as Mr. Matthews. We are grateful for this effort, I think, on behalf of the entire community of lawyers and people who are believing in rule of law. I should thank Legal Era for this Business and Law Congress 2021 to see what can be the progressive legal inventions for business continuity, jurisprudence, what should be the laws of this land, especially in respect of the new technical world that we are in, the challenges that we face or we likely to face in future, pre, during, and post-pandemic. We have all passed through this new era, as we call it, where we found right from the Honorable Supreme Court till our all district courts, we all started functioning virtually. Even now, most of the hearings are virtual, though due to change of circumstances and the pandemic having given us some respite, we have been able to bring hybrid system where physical appearances are also now in many of the courts have already started. But the fact remains is that we need to look at our future. We need to look at how do we will plan our rule of law under the constitutional norms, under the Constitution of India. And consequently, apart from what my colleagues in this panel would say, I would suggest that we need to look at our laws once again and see, especially the Information and Technology Act, to see where do we need to fill in the lacunas. How do we make it more transparent? How do we make it more confidential? And how do we make, at the same time, an effort by all of us to ensure that there is a speedy and cost-effective remedy and solutions, not resolution alone, though we have brought a very great IBC in 2016, which has changed the business community's attitude towards loans, etc. I find much more discipline in the business community than it was earlier. But having said that, we are still in infancy. We've just finished few years of our IBC, and we have now brought IBC even with respect to the personal guarantee of people who have been guarantors to the corporate debtor, though the remaining part is still to be notified by the government. But the fact remains is new challenges have come up because new situations will arise when you are having a corporate insolvency or a bankruptcy in relation to an individual. Similarly, in arbitration, we brought in, for example, Chapter 1A, we have not been able to notify it. We know all the reasons for it. We thought the arbitration today needs to be an alternative from stage alternative. We must bring it to appropriate dispute resolution and must make that, though we brought in the schedule to the fee to be paid to the arbitrators. We also, the legislature brought in the time limits for an arbitration award, but still there are many complex situations that we need to address. The many complications that are coming, especially with respect to the fact that new disputes, and I must share with this August gathering that today, only to take an example of Delhi High Court, if in the last 1.5 years, we have filed actions with respect to IPRs, for example, you would find about 63% of them only relate to IT matters. Computers, hard drive, what was mated, what was patented, what was the design. So new norms are to be coming in. If I go back to a few years, I remember a lyrics question was whether lyrics by one is sung by another one would also be violative of Copyright Act. The law has changed. We have undergone many changes. Law has now updated itself in India with respect to international standards. But we still have a long way to go, and consequently it is necessary for us to look at what as professionals, we should suggest, and in fact, with this forum, may I also make a appeal to my legislators, appeal to my government of India and the state governments, that time has come when you should make the committee to draft legislation, people who are in the job, people who are in day-to-day functioning of that law, so that they would be able to give you much more inputs and probably be able to iron out many other things that you otherwise sitting in your offices may not be able to discuss. Therefore, time has come. In fact, if you take an example from Singapore, most legislations, in fact, almost 99.9%, legislations are made either by professionals in the field, including the honorable judges who are dispensing justice in the Honorable Supreme Court or in the Federal Court. Therefore, the time has come when we should adopt that, something which is good elsewhere. There's no harm in copying that, though it's not a case of copyright or anything else that you're copying. You must look at it. For example, they brought those gyms convention within the judges to see how do we mention cross-border disputes and there are no conflicting orders being passed between the countries, between the two judicial forums or two courts. In fact, now time has come, we have to also look at it from the point of view, how do we get reciprocity on almost every country where a judgment is passed, whether in India or abroad. Time has also become, especially with the matrimonial litigation, for example, going multiple, where you find business community going multiple. You have a holding company in India and a subsidiary abroad. And an example of Jet Airways is before all of you, where we found an administrator appointed in a foreign country was allowed by an Indian court, recognized to be a part of the Committee of Writers. So these are new world changes that we are seeing. I don't think in the past 5 years or so, we have seen new avenues opening up to us. Today, the digital signature contract is accepted. Earlier, the view used to be that the contract had to be in writing, though we have seen many decisions where oral contracts were also implemented. But in the business community, by and large, we need to look at facts of each case, each transaction, not to go by a template that we have adopted, to see how do we change. And it reminds me, just on the lighter vein, not that I'm commenting on it. You see, you all know today Videocon is in a CIRP process. And in that CIRP process, when I'm talking, when it was not in CIRP process, Videocon was also doing petroleum products and was doing those, had machines, etc., to bring petroleum up. And in that contract, the contract had said the contract will be governed by Indian law. The arbitration in it was to be governed by English law. The curial law would be UNCITRAL, and the seat of arbitration was Malaysia. And that matter went on and on for many years that we have not been able to see an end to such litigation. Therefore, it's time for us in the business community and the legal community to join hands to see how do we bring clarity to the contractual rights of the parties as far as possible. We have seen during pandemic, for example, that force majeure clauses have created a situation which was unprecedented. We didn't expect, of course, a pandemic to come, but yes, but we have to take care now. And I must share that. I'm sure many of you have much more a better experience than I would have in my command, that during this time we brought parties on the table, mediated between them in a principle of mediation. So strictly speaking, it was not really mediation, if I will call it. But yes, it was a structured process by which we rewrote the contracts, made the parties agree to rewriting the contracts, including force majeure clause. Therefore, time has come when we must look at what are the actual transaction and intent of the parties. And the drafters of my friends who draft these documents, both in-house counsel as well as people who are outside in the corporate sector, must ensure that we must make clarity as far as possible with respect to the same. These are new challenges that we have. The new process that we saw in 2002, an amendment was brought in by the legislature for the first time to bring mediation back into the picture in the process of Code of Civil Procedure. we have now drafted, in fact, an expert committee appointed by the Supreme Court has drafted a legislation on mediation. It has gone past the eyes of the Honorable Supreme Court and has gone to the government. And one expects that soon we will have a mediation legislation in place, which will also be probably give way to the word conciliation or part 3 of the Arbitration Conciliation Act, and probably will move forward towards mediation, especially after in 2018 we have amended the UNCITRAL laws, and now that we have in place Singapore Convention on Cross-Border Mediation Agreements, which itself would become implementable without even going to court. So these are all developments in the right direction. Developments to make progressive, be more progressive, the rule of law, to ensure that justice, which is the heart of the Constitution of India, reaches out to a common man and reaches out to the business community more so, especially the MSMEs who have been suffered a great during this pandemic situation. Therefore, it is time that we all, this forum should be utilized, and I'm sure all my participants will benefit, whether from the panel of arbitration or the panel of mediation. Panel of virtual hearing, for example, is also a panel in this very session coming after this. Therefore, it is time that we all must join hands. I think a collective effort is required by each one of us. Each one of us must play a positive role to ensure how do we make the system more robust, yet friendly, simple, cost effective, and on timelines. India had not thought till it got 2016 IBC that it would be able to ever reach a timelines in the Indian judicial system. But yes, time has shown that we in India could achieve that also. Therefore, congratulations to all of you for contributing to the cause of justice at one time, but also appealing to all that we must also ensure for the challenges that we are facing today, especially in the economic front, especially the business community, we must join hands to see how do we raise the economy of the country. And I don't think it has anything relatable to any government. I think it's the people of this country, because my constitution started with the words, we the people of India. So if we the people of India are the mighty of the constitution, then we the people of India must join hands collectively from all stakeholders to ensure that we move forward, bring such more progressive laws, suggest amendments, suggest needs that need to be done, and this ad hoc arbitration must give way to a institutional arbitration. The mediation has taken many folds today, and I'm happy to see that mediation is today being used almost in every forum. There are compulsory mediations today in terms of Commercial Courts Act, the amendment. I'm sure Section 12A would be utilized by the business community to get to solutions of their problems. Conflict is inherent in any human being, and those conflicts have to be resolved, solutions have to be found. And with that, I think, I feel the present forum would help us to develop new exigencies, think about new things, invent new ideas, and probably place it before the authorities to see how the future of this country and the cross-border world can be safeguarded more on the economic front. So that business community, if that is doing well, the employment comes in. If that is doing well, many economic comes in, and that is doing well, a consumer gets the best. Therefore, from all fronts, we all need to support the business community. And after the gateway of India was opened by all those Raj of what we call licensed Raj, we should now take a step forward and meet the demands of this community in more progressive way. Thank you very much. Thank you, Shikha, for this opportunity. Thank you, Dean.